obviously, it's going to be an interesting session, I know, but at any point of time, you want to tell us about yourself, your wish, please.
Well, good afternoon, and I'm loving the flow of this already. Just jumping in, because I logged in early, didn't realize I'd come straight into a session. So Vikram, good afternoon, and ladies, good afternoon. So who am I? So I'm a mediator for the last 13 years. I am a legal academic, so I continue to do research in the space of mediation and family law and dispute resolution. And I'm also the chair of the Irish Professional Mediators Organisation, which is a national body which has members who are mediators. So I think for me, the starting point, and Vikram, I love when we talk because it makes me go away and do some more homework and look again and fresh eyes, so my starting point is I look seven generations back and 7 generations forward to see where did we come from and where could we go. So in that time span, like where we're standing here today, if I just look at the Irish context, so before we were colonized, and I know we've had this conversation before, but before that we had this thing called Brehon law. We had no police force, we had no courts, we had no centralized system or state organized oversight of dispute resolution. So it was organic and it was at community level. And then, and that was like up to the 7th century, it was completely oral, and then it was written down, and then we got colonized. So between the 12th and 13th centuries, the English took over Ireland essentially and colonized us. And so that then meant 8 centuries of a legal system that was imposed on our culture. And so when you have 8 centuries of a system, it's embedded. And not only is it embedded, it's not questioned for most of that period, because it's accepted as the structural space within which we operate and we live. So now we're in the 21st century. And so the question for me, and I think this is the question maybe for this session, how do we move societies away from this presumption that the first step is to seek legal advice with a view to litigation? How do we make it more normal that we think, oh, I'll pick up the phone to a mediator, or I'll pick up the phone to somebody who I know is going to assist with this dispute? And that's the question that is burning for Ireland, for India, for Turkey, for England, for Australia. Nobody has figured this out. And I think maybe that's nice to know, because sometimes we might think some other countries have figured this out and are ahead of us. They're not. And one of the similarities I see, because we in Ireland are talking about this idea of a mediation council because we have mediation legislation, and we'll go into that in a bit more in a minute. But I had to do homework on every member state. What is every member state doing? What kind of regulation? What kind of legislation? Do they have a council type thing? And I looked at America and Australia and New Zealand and India. And when I got to India, and maybe this is why you and I first connected, Vikram, I was fascinated with the developments in India because there's some really interesting and not so good things happening. So the really interesting would be our Law Reform Commission kicked off the development of legislation in Ireland. That's how it happened. It wasn't mediators, it wasn't the state, as in it wasn't government. And in 2008, India was identified as having a really old tradition called panchayat. Would that be right, Vikram?
Yeah, the pronunciation is almost there, but the concept I have a problem with, which I will discuss with you.
Okay, so our Law Reform Commission said, hey, let's look at India. They have this 2,500-year-old dispute resolution mechanism that's used for commercial and non-commercial disputes. And then let's look at other countries that have other older mechanisms. But what our Law Reform Commission said in 2008 is, hey, we've got a really big problem here. We have a whole lot of people running around the country calling themselves mediators. They're not governed by any legislation or regulation or any framework. And who are they? And do they have training? And so it's the Wild West. It was the Wild West in 2008 of mediation. And the Law Reform Commission also said, we've got a problem with mediation and conciliation. And they determined that those were two separate and distinct things. and we're being mixed up all the time. Now, this is just the view of the Law Reform Commission in one country, okay? And I think what was interesting about that is they said they actually gave two definitions, which are so mediation being a process that facilitates an agreement, and conciliation being a process that facilitates agreement, sometimes advising the parties about an agreed resolution. So that's what the Irish state thought it was back in 2008. And then if we look at the UNCITRAL model of 2018, and if we go back to the earlier one, if we look at, where's the one that was earlier than that?
Conciliation rules 1980?
Yes, thank you. The 1980 ones. So that's really interesting because that really speaks about, the definition is that these are the rules that apply to the conciliation of disputes arising out of or relating to a contractual or other legal relationship where the parties seeking an amicable settlement of the dispute agree to the rules, that these rules will apply. So that was the rules on conciliation. But when that got transposed into Indian law, which I found fascinating, that was the 1996, so the Arbitration and Conciliation Act 1996, the definition in that act only described arbitration. So even though the name of the act is Arbitration and Conciliation, it only describes arbitration. So that was interesting.
No,
and then we
okay, maybe but no, we have a separate section in that on conciliation, so which is standalone. It's actually kind of standalone, but it forms part of the same act. So it is because it's connected to arbitration to the extent of that being as good as a consent award, and then of course what would be the if it is as good as a consent award, then how you can challenge that. So I'm just saying that part is, I mean, it's not something which is only arbitration. It is that conciliation.
Well, no, it is. But I think really what I'm trying to get across is this connection between arbitration and conciliation, and there isn't an international consensus about what mediation is distinguished from conciliation, or is it the same thing? So within the Irish context, we've decided it's not the same thing. So we have a Mediation Act 2017, and we say that it is not conciliation. So the Law Reform Commission are really clear. This act will be about mediation, although initially the conversations were about, are these interchangeable words? And then we moved into the Mediation Act. So conciliation is gone from our act, but we do have an evaluative section, which is section 8.4, where mediators can put forward proposals for the resolution of the dispute, but self-determination remains. In other words, it's for the parties themselves to determine the outcome. So it's evaluative really in nature rather than conciliative. So, but we do have conciliation in Ireland being operated by the Labour Relations Commission to resolve disputes, and it's used extensively in the industrial section, so construction industry, to resolve disputes. So even though we have legislation for mediation, we still have this conciliation piece humming in the background or around, you know, because that actually came from, I think that came from the 1st century. Yeah. So the conciliation piece in Ireland came from the 1st century, which was a merchant dispute mechanism to resolve commercial disputes between merchants, and that was international. So I think really, where are we now in terms of what has legislation done to the practice of mediation in Ireland? My view is that it's been hugely beneficial because it put it on the table for discussion in a way that the public had not. Mediation had never hit public awareness as a thing. So now it has kind of come on the table as a thing that happens. And Vikram and I were talking about this. There are two ways people are becoming aware of this. One way is that they're already in court. And when they're already in court, a judge can ask them to go to mediation, not direct them, but ask them, will they go? But people are taking that as a direction or an order because they're saying, we better do this if the judge wants us to do this. And you, Vikram, were saying this really is a symptom of overloaded courts, overburdened courts, and the system getting rid of the problem, like sending it back out the door. And I actually don't object to that because I would prefer they get out of there. One way or the other, I prefer they get out of there, that they get out of the court system. But what is interesting for my professional practice, the Mediation Act came in 2018. And in the year 2018, the referrals that I got from solicitors went off a cliff. So they went from 97% referrals from solicitors down to about 2%. And then what happened within a few months was that the clients started coming directly. So people were Googling mediation and finding me. 97% of my work now comes from a person who has a dispute. No legal representative, no lawyer, no court proceedings. They're coming straight. And I find that out because I ask every single person when they call, how did you find me? Well, I put you into Google. So, and because we're running an organization of Mediator members, I'm asking our members, how are people finding you? And something really similar is happening for everybody. So that's interesting because it means the public are now thinking, how do I get a cheaper space? Because that really is the driving force for most people. How do I, because Irish legal costs are extraordinary. To go through a very ordinary separation, you're looking at between 20,000 and 55,000 euros per person, because it's common law jurisdiction and it's battled out in a courtroom. If you're doing a commercial dispute, you could be looking at hundreds of thousands. So people have this awareness of cost. And that is the greatest incentive not to step into the litigation space. But I think the problem that we have is a similar problem everywhere. The gatekeepers for disputes tend to be lawyers. And once a person goes to a lawyer, they get an advocate view of one side of a dispute, or even a 50-50 possible outcome of a dispute. And the mindset shifts when people start into the space of legal advice, their mindset shifts. And to shift them back from that to opening up to all possibilities is very hard, but it is doable. So I think that's the context of where I'm coming from today.
So what I'm going to rush in is what I did not do, which I should have done, is let's put out what we are doing here. Because I think what happens is that of course, I start off abruptly and then we just, okay, this is what we are doing. Mediation Legislation, Symposium number 8. And of course, all the questions that we can ask, we should ask: how, what, when, where, which, who, why. And Roisin, of course, is here. So this is what we are doing here. And I think now there are about 50 speakers from some 30 countries. So it's going to be a long one. And I'm going to maybe put out more slots. So I think let's get in more people, because I think we need to get in views from all countries. But let me just clarify on the things that you said, because you rightly said that panchayat word comes up when mediation is discussed. And if you watch the session, earlier sessions, I think with Mr. Panchurli, that the linkage of panchayat with mediation has been it is the worst thing, and it will be the worst thing for mediation, because there might have been a concept of panchayat pre-colonial times, maybe. Okay, the whole concept might have been different, but there's no use of that, because today in the village, the panchayat is understood to be a body that makes decisions or takes decisions.
Okay.
Now, when you go out and connect it to mediation, they think another person is coming to take a decision for them.
To make a decision.
Yeah, so now, for me, the job is to actually tell them this is not what the panchayat does. Can you imagine that? So it's a totally different angle. And our Supreme Court, in its own training manual, has also said that panchayat, when they talk about mediation, they talk about panchayat. Now, the ground realities are different, and you are sitting there creating some theory which goes out to the village. For me, look, I've always been saying 1 billion people stay in villages in India. Let's look at how they are going about things. If we have to do a grassroots movement, at least the people who should benefit are the people who are disconnected to a great extent from the court system, because our Supreme Court, we have one Supreme Court in Delhi, where I am, which is maybe 2,500 kilometers from one part of India. Can you imagine how disconnected a person is from the courts? High courts we have every state, and some of them might be 1,500 kilometers from someone's village. So from that perspective, I think we're doing disservice to mediation by connecting it to a process which they think is decision making. So that's on that part. On the conciliation mediation part of it, the point is that someone maybe they would law commission or whoever, when they're going about it, I think did not go back to see where did this word come in. For us, I know I'm not saying about Ireland. Ireland can have a different situation. For us, that word has come from UNCITRAL's conciliation rules 1980. And for that, when the UNCITRAL itself goes out and explains this very nicely in their model law, I don't know why people are not looking at it, because I don't know. Is it a vested interest? I mean, I don't want to now put it down to people and talk about it, because it is a serious thing to make allegations. But I think a lawyer or a judge, I mean, the judiciary itself talks about it, say there's no law on mediation. And I have to put this out there, which is from the mediation, the model law that the UNCITRAL has put out. If you read this footnote, I don't know if this is too small, I can increase the size of it. So nicely they put it out here. In its previously adopted texts and relevant documents, which all use the term conciliation with the understanding that the terms conciliation, mediation were interchangeable. In preparing this model law, the Commission decided to use the term mediation instead of, in an effort to adapt to the actual and practical use of the terms, and with the expectation that this change will facilitate the promotion, heighten the visibility of the model law. This change in terminology does not have any substantive or conceptual implications. This applies totally to India. Totally, because we picked it up from the word that they used. Today they are saying we are using this word, but it means the same thing. So, and of course, in the definition that they put out of mediation, also they've said the same thing. Because the point is that it's not the word that matters, it's the process. So it, for the purposes of mediation, means a process whereby, I mean, whatever else, expression, mediation, conciliation, or an expression of similar import. So, and then you look at the process, what they're talking about, and request a party to assist them to attempt to reach an amicable settlement of the dispute arising out of or relating to a contractual or other legal relationship. This is what you were saying. The mediator does not have the authority to impose a solution, is what we have to really put out. So from the Indian perspective, and a lot of other countries which might have got the word conciliation from here, this applies. Some countries legislated conciliation differently. Like in Brazil, there is, we'll have someone from Brazil, we talk to that person, but they have a specific legislation which talks about conciliation differently from mediation. So in that case, yes, their law will apply and their understanding will apply. So no, I mean, no two ways about that. That if you say that mediation, they say is facilitative and conciliation is evaluative, they put it in their law. So that's a different concept altogether. But when we are talking about it, we will have to go to the foundation of where we came from.
I'll go back.
Yeah.
Well, there's two pieces that worry me about the mediation bill. That's the Indian mediation bill.
It should not be there. I mean, the
mediation,
so how not to legislate bill? Yes.
well, first of all, I agree with you. First of all, I don't understand why this bill is coming forward, but okay, it is there. But there's two pieces in it, and the reason why one of them really stands out to me, because we're dealing with exactly the same thing here at the moment. So the two pieces that bother me are, first of all, the definitions, breaking mediation up into different kind of sectors and categories, which is a really strange thing to do. So court annex mediation, litigation, online, community mediation. Like, why? To me, mediation, like, we have a very simple definition in our Act as to what mediation is. I might just read it out, because I think mediation for me is just about, can you describe what the process is, not how or where or why it'll be used, you know, what sector. Like our definition is, mediation means a confidential, facilitative and voluntary process in which parties to a dispute, with the assistance of a mediator, attempt to reach a mutually acceptable agreement to resolve the dispute. That's mediation. Whereas the mediation bill, the Indian bill, is putting it into kind of sectors or something, but the thing that really worries me is your section 34, which is the composition of your mediation council. So we also have a provision for a mediation council in the 2017 Act. And the provision for our mediation council was to create an independent corporate body. So that's similar to the piece in your section 34. And that independent body would basically regulate mediation eventually. So initially run a national register of mediators. That's in your bill as well, Vikram. That body would determine the training standards. So accredit training bodies would, you know, so all of the functions, all the kind of regulatory functions your council and our council are envisaged to do. The really big difference, and I thought ours was bad. Okay, so the really big difference is, our council would be comprised of 5 member seats from nominating bodies who represent the interests of mediators, and 6 seats that would be the public interest seats to represent users of mediation. So the majority of the seats would be public interest seats to protect the public who will use mediation. That's the idea. The battle that we have going on is over the 5 seats, because what has happened is Chartered Institute of Arbitrators, Law Society, Bar of Ireland have come forward and are seeking one each of the 5 seats to represent the interests of mediators. But it's quite obvious that those 3 professions compete professionally as dispute resolution forums against mediation. So if you have a preponderance of member interest representation for bodies whose first interest is another form of dispute resolution, that's a difficulty, and we're trying to work our way through it. But the Indian draft bill is extraordinary in terms of composition, and I think if this happened, mediation could get destroyed in India, because what this composition piece is, out of A to F, like I think it's 7 seats, only one person would have knowledge or experience of mediation, not even be a mediator, but just have experience. And almost half the seats are government officials. What on earth are they doing there? And then you have a person of ability and integrity to be the chair. What does that mean? And then you have one person who might have experience of mediation in terms of research or teaching. I think this is a disaster in the making, because if that's the composition to drive the professional development of mediation, it will drive it over a cliff. That's my view.
What we're going to talk about is we're going to call it the X bill, because luckily it went into the parliament, it went to the upper house, as we call it, the Rajya Sabha, and it was sent to a standing committee. The standing committee has sent it back with a report, and they've given their comments on this bill. So it's gone back now. It's not, this is an X bill. They of course are going to rework this and send it back. Hopefully somewhere down the line, some sense prevails. But let me give the background is that the Chief Justice of India sets up a committee. Okay. Committee has, yesterday we had Mr. Panchu, he was in the committee, but he said, I will not talk about the bill because, because the point is the committee drafted something, sent it to the government. What came out on this mediation council was totally different in terms of structure, what you just read out. So that was not what it was, the thing that went to the government. But that's a separate thing. For me, the base itself is wrong. Chief Justice of India, now you are going to start looking at law making also. Let something happen. Let the legislator do something, because Supreme Court judgments by themselves are law. Now we will draft law also. So now let us just run the country also. I think that, because the public interest litigations by themselves run a lot of things to do that. So it's an issue that side. So I don't think that was a good foundation. Then they had committee, they had training institutions. Training institutions have a vested interest. Judiciary has a vested interest because they have a backlog. People with vested interest are sitting and sending a certain a draft to the government, I think, and putting pressure. But when the Chief Justice is sending something to you, you have to look at it and say, okay, I have to look at it. And the relationship between the government and the judiciary is always a little, I don't know, let's say whatever it is. I don't want to say what it is, but okay. So there's an issue there. So those are the kinds of things. That's the background in which a bill comes in. And then, I mean, within the government, how much of an understanding, which we had seen the way it was put through. I mean, it was just taking things from here and there, let's put it together. Now, that's not the way it was supposed to be, but there was a kind of, it was something like, I would think, let's put it out to the parliament. And maybe there was this understanding that maybe it is something being pushed on us, but let's put it, and maybe some sense prevailed and let's send it back, kind of thing happened. So I'm not getting into processes that have happened, but I'm just saying, let's look at it as an X bill. Let's just look at that, and whatever issues there were, we should discuss those issues. And hopefully this is not the bill that goes back, and it goes back with major changes, but you should have a look at the report. So have a look at the standing committee report. They've looked at all the various things, and they put there on each of those sections, they put some comments there.
See, one thing that struck me as well, and I'm also looking at another international piece. So we're each from our separate countries. And there's developments on the ground, all happening at the same time, all slightly different. That's human nature. That's the evolution of the human species. We tend to work in little spaces and do our own thing. And the globalization has meant that there is more information moving, and so we get more information about what other countries are doing. But then we have the international context, because our families and our disputes and our people don't live in just one country. They move. and they may have their dispute in one country, but they move. And then we have international conventions that have come into being. So we've got the UN Convention on International Agreements resulting from Mediation 2017, or the Singapore Convention, as everybody's calling it. That excluded employment law disputes and family law disputes. So I'm currently looking at, and I've asked Vikram to put his thoughts on this as well, what kind of convention can we create for family law disputes that are international in nature? Because we have nothing at the moment to help us. I'm doing quite a lot of mediations that are international, and recent ones that are completely in UAE. So they're in the United Arab Emirates, and they're not even anywhere near my country, but I'm mediating. So I'm having to work out the rules for myself as I go, because there are no international principles or umbrella sort of guidance. And we have 55 signatories to the Singapore Convention, but only 11 have ratified. And India have signed, but haven't ratified, as far as I know. So one of the issues, like the UK have only just said that they'll sign up to it now, but they won't ratify it yet because they're worried about enforceability. So it does come down to, when we have a dispute, and if it needs to have enforceability, where do we go with it? What do we do with it? So on a national level, we have to understand what is an agreement that's capable of enforcement, and why would you want to enforce it? So if it's a standard contract, we can understand that. If it's a separation or a divorce, we can understand that. And so we need to understand national law, and then we need to understand, if you create an international agreement, where is it going? If enforcement is needed, for the nature of the dispute. So I think we do have to think big, but as we move in this space, we have to be very careful not to reduce or narrow what mediation is, because mediation needs to be the very broad, diverse space of practice that it is, all the way from a dispute between neighbours to a very, very high value commercial dispute. I mean, the types of mediation I get are breadth of information I get is just extraordinary. I get all kinds of different cases. So human beings come into dispute, but we have to think about principles rather than black and white law that constrains what we do, I think.
Yeah, absolutely. I think that part of it needs to be looked at and worked on. But the only thing is that, look, how much of it is, okay, Seville wants to say something. Yes, Seville, you wanted to say something? Yeah.
So I wanted to give an example. I had talked about some very detailed legislation that were even cancelled by the Constitution Court in Turkey. Going back to that, I remember one very detailed legislation that was saying that the mediator should start by calling the applicants. This was cancelled, and not the lawyer. Even if there is a lawyer, the mediator has to first call the applicant. But the mediator may look to the file and may find the other party to call. That is going really too far on what to do. And the rule maker is trying to put rules on everything, and then it gets reaction. And it doesn't fit all cases. So this is not something to legislate, if this is the question. I think this is a good example.
But Roisin, what I was saying was that, look, you're looking at in terms of family law matters, in terms of convention. I'm saying that this is an opportunity where people who, I mean, when domestic legislation is being discussed, let's look at enforcement as part of domestic legislation. I mean, convention is only there to tell you that, okay, this is your, in a way, something that you're going to do. Yes, you have, if you say you ratified it, you of course create that legislation. But without all that also, I mean, the fact that it's international commercial mediation covered under the Singapore Convention, that was okay. The UNCITRAL was looking at that only. But domestic legislation can enforce anything. I mean, we should be looking at putting that out to governments everywhere, that you can, when you're creating or in your domestic legislation, look at enforceability of these kinds of situations that come up. I don't know why we need to even get into any UN convention also.
Well, I think the family space is quite complicated because with family law, by sovereign state. You have rules and regulations around children, residence of children, property, pensions, and they can be in different countries. And so guidance or guidelines about how we could best manage this international space, I think would be really useful, but it shouldn't be something that constrains. I think it's too, first of all, I always think from the perspective of the user of mediation rather than the mediator, because I prefer to start there. So if I'm going to use mediation and I'm in Turkey and my husband is in America, how do I know about using mediation in that context? So what I want is some sort of clear information for users of mediation, particularly in the family space, that look, you can do that. You can go to mediation. Here's how you do it. Maybe you have a mediator in each country and you do co-mediation, or maybe you have but the enforceability of your agreement is really important, because ultimately every country has divorce legislation. And if this agreement moves on to be part of a divorce, if it doesn't have some of the key pieces required in a particular country, or doesn't deal with assets that might be spread over multiple countries, then it makes the work that the users of the mediation have done and paid for something that has done them as a disservice if the mediators don't understand what they are doing. And that's really, I think, the complexity about, like, I love, there was one conversation I had during the conversations I was having about with each member state and trying to understand what's happening in each member state. And a mediator said to me that why were mediators so obsessed with process and structure and rules and regulation when the users of mediation don't want to know any of that? They want to know, what can they do in mediation? Can they get to an agreement? Can you take on this kind of dispute that I have? Can it be done? That's all they want to know. So I think really the rules, the regulation space, from my perspective, Vikram, I think that's important for mediators to understand, not the public who use it. And the public's only piece that they do need to know is they need to know that mediators have a certain competency or standard. They need to be sort of feeling comfortable, if I go to this person and I go do this work with them, is what they're going to do with me sufficient? Because a lot of people don't want to go to lawyers. And then you create the situation where a mediator is creating an agreement that the parties would like to be binding between them. It's their agreement. They want it to be binding between them. But if the mediator doesn't understand enough about the context of the dispute, they could do a disservice to the users. And I think that's, to me, the power or benefit of legislation and regulation.
This part of it, look, I have my thoughts on this, because for me, the point is, first of all, who is that mediator? I mean, like I was last session, I was telling Judy and hey Heidi also, who makes a mediator?
Yeah.
The people in dispute make mediators, and they should be able to make mediators out of anyone. Because if once they don't have that choice, you've gone. I mean, the first principle part of it, but the self-determination aspect is gone, because it's their choice, whoever they trust. I mean, first of all, who are we to tell them whom to trust? That's the colonial mindset, that we will tell you whom you can trust. Then the other part of it is everything in terms of certifications, training, and all that we go through. I still feel that that's a colonial thing, because who's legislating? Our legislators, I don't know about your country, our legislators don't need any qualification, no certifications, no accreditations, and they're legislating for us. That doesn't surprise anyone. That doesn't scare anyone. But what scares us is that, oh, those people who are going to, that mediator is going to sit with these people and will do some major damage or something. What are I'm saying that I'm sure there are more legislators who have done damage than mediators who would have done it. So I think that first thing, everything is themselves, the legislators themselves think that everything is not to be legislated. Everyone is not to be legislated. Let the people decide whom they trust in terms of whom they elect. That is all right with you. But here...
Well, yeah. I wouldn't, okay, I challenge you on that, because I wouldn't compare mediators with legislators. And I think that's a really interesting point, because legislators don't have to have any particular training and off they go and they do that. I compare mediators to nurses or doctors or acupuncturists, or we provide a skill, we provide assistance it is not our mediation, and it's not our dispute, and it's not our outcome. But we are skillful in helping people come to that space. And I suppose the reason I have concerns about this is over the years, I have seen some absolutely terrible mediation agreements. Terrible, because I do research in the courts. And so eventually they make their way into the courts, these agreements. And then judges look at them and say, what is this? What is this thing? Because it's not anything that I can enforce. And it's not even a question of something being in legal language, because I think the great thing about recent developments is we've moved a lot away from this using of hereafter, thereby, hereunder, all that kind of old archaic language is going away. But if even in plain English, if an agreement is not written in a way that meets even the fundamentals of contract law, it is not capable of enforcement. And why is that important? Because if the people who reached the agreement intended it to be something that was binding between them and find out that it is not, that's a disservice to them. And they have wasted their money with someone that they trusted as a professional. That's a different dispute space to, say, two people in a community who are having a really personal conflict with neighbours, and they go to a trusted person in their community and they seek support and assistance to get to an agreement. Usually that kind of agreement is not intended to have any binding force or outcome. It's more relational or transactional, not transactional, relational in nature. And so that type of mediation needs to also be protected, that we don't regulate or legislate such that we turn mediation into a thing that is so close to arbitration or even litigation that we've lost the great diversity of what mediation can be.
Well, I tell you, if you look at, I mean, of course, I've had those discussions. So, of course, the whole series of discussions I won't have here. But the point is that there is something that you have to, from your side, understand in relation to what is mediation and who is a mediator for the user.
Yeah.
And it's not about the community or anywhere else. The point is that everywhere that you will go, the development of mediation for me, of course, did not happen only because that first aspect of developing that culture as to that a third person available whom you can go to, I think that culture itself got destroyed. So that's where those discussions on mediation in our culture and tradition. So, but first, I think that foundation, if it's not there, then to develop anything beyond that, to say that, like, it will always, I think, get absurd and more absurd as to who can be a mediator, who's going to decide that, who's going to tell you that this aspect of a person is what you have to look at. There's so much more which is happening in relation to a mediator. There's lots on the other side. So I'm not going to get into each of those aspects, but all I'm saying is that why I said the legislators or the politicians or whatever is because on the trust part. I trust this person to represent me. Who are you to tell me what qualification that person has? From the trust part. If you were comparing it to the nurses and all, I'm saying, what about comparing them to mothers? Are you going to tomorrow, you as legislators, decide what the qualifications and certifications of a mother have to be before she becomes a mother? You can everything doesn't need to be legislated. It's a relationship that the people in dispute have with this third person. I mean, if they understand the process, the problem is, do they even understand the process first? That they can walk out of it anytime they want. It should be as flexible. They do not have to go through it if the trust is not there. That's the end of the whole process. Do they understand that part? So I think that first thing is the understanding of the process that you're getting into. And the person that you're getting into, I'm telling you, if you think that anyone is going to talk about everything with everyone, it doesn't happen. Mediators are gauged at every step, at every point of time, all the time. It's first of all, it's again, I use this again from the colonial concept. You are savages. You don't know whom to trust. We will tell you whom to trust. And we have a set of people. We have everything has to be structured into some training and certifications and all that. We've got this set of people. These are the people you can trust. These two of you sitting, and with this person, how can you trust this person? This guy can do damage in your relationship. It can do damage in the way it's going to be worded. So if there are apprehensions, I don't know how many of whatever mediations you spoke about, but whatever has come out from that in terms of language, the way it is structured, I am saying that put a little format at the end of your legislation, that with the settlement agreement, should be the format. You just put this, whatever this dispute, to list it out in this manner, whatever. I'm not saying what format, you can create a format. If that is the worry, that okay, this is not structured properly, do that. But to say that because of one person not being able to put it together properly, we should, I mean, the whole process should be looked at from the legislating point of view. How many politicians are corrupt? Do we stop politics? So many other, I mean, everything, one exception is not going to make the rule in this case. I think it's just a matter of us wanting to get into this field, thinking that this field is something that we can structure. I am saying it will never develop that way. It hasn't developed that anywhere. I don't think today, most countries, we were talking about with Julie and all, also in the US, full-time mediators is not a rule. It's not, it's a rare thing. It's not something that, and over years of the mediation being promoted and through the court system. Today also she's saying everyone knows about mediation through the court system only. It's not, and is it settlement conferences happening there, or is it mediation happening there? Those discussions. So I think there's lots to happen, Roisin, and I think it's a good thing that you're getting into all that. You'll come out with something good. You'll come out with a uniform law, which.
Well, I think we are actually at a tipping point. Like these life cycles are really interesting, and I think, you know, one of the pieces about our conversation is that it's not that law and legislation and isn't existing already around mediation. It is. It's all over the world. It's already happened. It's already well developed in all kinds of different ways, right across Europe, America, like it's everywhere. So what are we talking about now? We're talking about not should there be legislation around mediation, because there actually is, but should we be cautious about how we regulate mediation and how we regulate who a mediator is? Yes, I agree with you, because my experience is you actually can't train somebody to be a mediator. That's my experience so far, because I don't even quite know what that fundamental X factor is. I do training and I train people, and you can see the natural mediators because it's a personality piece. And it's actually about who they are and how they present themselves. And then they can learn skill sets, and they can learn information, and they can learn competency in different. So in our membership body, I am doing what you just suggested, Vikram. We are creating guide templates, you know, structured. Here's the things that need to be in your document if you're doing this kind of agreement. Not here's how you write your agreement, because that's up to the parties. But here are the things you need to make sure that are in there. Here's a practice note about how you might go about this. Here's the things you might need to find out. It's to a mediator, just to help the mediator understand if the parties are telling me, hey, you know what, this dispute, we intended it to be binding between us. I don't want mediators to go, whoa, what the hell does that mean? How do I do that? What does it mean? What should that thing look like? So I want to make sure that, like, for example, the trust thing, I think this is really interesting. So most of the clients that I'm now getting, and I'm full-time as a mediator, and I have a huge amount of work coming at me. And when I ask them, where did you find out about me? It's the reviews on Google. There's a business section within Google, and people are trusting that. This is a different world that we live in. And I say to them, okay, it's great that you've come to me, and it's great that you read that review. Do you really trust those reviews? And I said, I haven't written them. I promise you, we didn't go anywhere near them. But why do you trust them? And there is this really strange, interesting piece about people where they see reviews on a shopping website or, you know, about a lawyer, about a mediator, and they're trusting it. And so that's the community space that they're coming into, to choose a trusted person.
But I think it's not. There's still that's the starting point. They come to you
Yeah.
because of that. That one conversation that you had with them, the
Yes.
three lines that you said, from those 3 lines itself, that trust factor starts, not from anything else, because that's, look, it's something that is going to now, you're going to work towards getting them into the mediation. So that process has to still happen, but they won't go through that process up till in that conversation with you, they don't trust you.
Exactly. And I think that's the key piece. The most important thing is the phone call that you have to talk about what do they need. That phone call turns it into a mediation case or not. And if you don't develop a rapport with a possible client in that phone call, they won't go forward. So that what they are doing, it's very human. What they are doing is listening to your voice, listening to how you respond to them, feeling how they feel about you. And that's what we do when we try and connect with another human being. And that is what turns it into a mediation case, always. Because I always say to people, I understand you're feeling stressed, you're feeling angry, you're feeling frustrated. I really do understand that. But you can trust me. I do this all the time. I will quietly, gently, respectfully help you both walk from here to the end of this journey to start the next phase of your life. So it is about people feeling protected and kind of cared about while they get through mediation. And I think the two ladies have their hands up, Vikram. I think we better let them.
No, their hands, they are going to come in. But first, what I want to get into is that this aspect, where they came from, how they found you. Good question.
Yeah.
But I think the next question is, after you spoke to me, why did you still go with me? What was it that maybe why did you trust me? Let's find out. Let's see what they have to say. That's it. Is it the way you spoke to, what did you say? I mean, I don't know what they will come up with.
I actually do ask that at the end. When I finish a mediation, I always ask that. What was the factor? Because it's learning for me as a mediator. I always ask, what was the determining piece? What about that conversation made you feel this is the right person to go with? And every single time they're saying, well, you listened to me and you seemed to care. That was it.
Yeah. And I think they might not even have words for that, because I'm telling you, these are experiences. You experience a person, and what all you are gauging at that point of time, no one knows. I mean, no one knows. This is a subconscious mind which is looking at so many factors. To ask someone to put those things into words, they will not be able to do it. And that's why that symposium, heart, soul, spirituality, and mediation, there is lots happening which doesn't have theory available to it. So now let's get Sultan in first. Yes, Sultan, you wanted to say something?
Thanks, everybody. I must leave. Okay.
Thank you,
See you
Sultan.
later.
And
See
yes,
you.
we will have further discussions on the 19th. Please drop in for that session.
Yes, see you.
And up to then, please
Bye-bye,
work on.
Sultan.
Several was wanted to say something.
Yeah. First, being a little more pessimistic about the trust issue, then I will get to the positive side of it. Most of the people, I think, are not looking for trust, but because of power imbalance, they are looking for the contract they want at the end. Because they are on the powerful side, they just search for some mediators that would just guarantee for them to be stronger on the end. And the other side may not even realize that there's something being abused there. But sometimes they realize. And it is a very painful process, I think, and it is long. There may be very, very bad examples going on there. And those rules and legislation are trying to get rid of those and maybe solve those problems, but in the end they create other problems because you cannot fix it by legislating. In the end, we have to get through this trust issue, and I am on this side. I'm trying to do the right thing and not bending anywhere, and in the end, it's get some rewards. In the end, you get some recognition, but it's not easy and takes time, I would say. And but at the beginning, those certificates and training at least gets you some experience, and first you cannot be discovered without them. You just get lost between all those bad examples. And other than that, I got a lot of things from the trainings. It wasn't just the mindset. I got a lot of training, and even my mindset, I think, has changed through those trainings. I changed my whole life, not just the training and not just the job, my personal life as well. And I think all was going through, it helps me in this way, I would say. And what else? And training, it shows that you have some devotion to it. You want to do something, you put your money in it, you put your time in it. Then you expect some reward. I think that is something. And about full-time mediation, I'm an advocate for that. I think if you choose to be a mediator, then I would be ready to leave being a lawyer. I'm still a lawyer as well. But if there was a distinction between it, I think it would become much, much more professional than those people that just want to be a mediator, that has the mindset for it. They will be remaining in the section, and it will really change everything, I would say. And then people say, okay, but that's so I cannot be earning enough money. No, I would say, because if there wasn't so many people in the field that really doesn't care about the mediation itself, but just the money that comes from it, they would be just eliminated, and you would be also gaining money from this job. It could be a profession in itself, I would say.
Yeah. Those are general discussions we have to have, but Roisin has to take us through legislation in relation to certifications and training. Is there something in relation to legislation that you want to talk about in these cases?
Yeah, I think I've been struggling with this, and I think we're going to have to go very carefully and very slowly around this training piece, because we have this kind of this thing of X number of hours you become a mediator. So in Ireland, it's 60 hours doing a training course. And I know when I did my 60 hours, I should not have been let loose on people. My personality is good for resolving disputes. I was always the person in my family that resolved disputes. In my close family and my extended family, everybody would come to me. So it's a natural, it's my personality. But when I did the training and went straight into doing a mediation with two strangers, and they were fighting and shouting in front of me, and I was, whoa, what do I do here? So I don't think 60 hours is enough, but what is enough? I don't know yet. I don't know. I do know, for example, if you're doing very specialist mediation work, you do need knowledge in that space. If you're doing divorces or separations, I don't think you need to be a lawyer, but I think there is a sufficient legal information piece. And how do you get that? So I don't want people to have law degrees or be lawyers or barristers to do certain kinds of work, but I want to try and understand what's sufficient there, what's enough to understand. And maybe that can be done, as we were talking earlier, Vikram, about through practice notes and guidelines about, you know, the format of an outcome, so people know what it might look like, the elements of something that gets agreed. So I do think there needs to be better approach to standardization of what do we say mediation training is, but I don't yet know what it should be. So I would be very opposed to mediation legislation moving on into that space yet, because I think we don't really know what we should be doing there. So all I want for now is national registers, membership bodies who really help their members who want to be professional. Like I do it full time. It's a very good income. It's a very good living. I'd like to see more people like me. Like in Ireland, there's only about maybe 100 people who are doing it on a level that's professional, getting paid. In England, there's only about a few hundred people getting paid for mediation work. And in Romania, for example, there's a huge number getting paid because the government is paying them. In Holland, Netherlands, there's a huge number getting paid through the state. So there's all kinds of strange pieces around how you earn in this space. I think the developments of mediation legislation are showing a certain consistency country to country to country, but driving some of the developments are other interests, and that's what we've got to really be cautious about, because other professions are in there driving the direction that they want mediation to go. And that's something we've got to be very cautious about, because mediation is not a legal it's not a legal practice, it's not a legal service. And so we must be careful to keep it in the space in which it has developed for thousands of years, which is a very organic and can have legally binding outcomes. So very organic at the community level and legally binding outcomes at the more structured level, but it is all mediation. So I think on that note, Vikram, I have to leave because I have
30 seconds more. You'll have to give me 30 seconds to the extent of
okay.
you've had a look at conciliation as it lies in our books, and do you think, for me, that's the way I would want it to be legislated. So any quick comments on that?
I think that's another day. I think because I don't think I can. I don't think I can.
We were going to get to.
I don't think I can give a quick one on that. I'm not sure that what you're doing in India, I'm not sure that you can rely on the 1980 Act or even the 2018 model. I think, well, you've transposed the 1980 one. I don't think that's enough. I know you do, but I don't think it is. And I think what I might do is think about this and put up a post about why do I think, because that's a more broader piece. I really welcome the opportunity to have these conversations. I have a client coming in now, so I have to leave. Thank you so much, Vikram.
And
thank you for hosting this.
Yeah, we can maybe do a part 2 in the symposium itself. Maybe we can do a part 2. Let's do that.
Sounds good.
But that discussion is required. All right. See you.
Okay.
Bye.